Hi, thanks for using my court coach. I'm Sarah and I'll be your instructor today as we discuss the petition for dissolution, legal separation, or a nullity, also known as Form FL-100. As with all our court forms, you want to fill in your identifying case caption information. If this is the first form you're filing as part of your divorce or legal separation case, you probably don't have a case number yet, and let the clerk that will be accepting this filing fill that in for you and assign you a case number. Below that, we are going to list what the relief is that we are requesting. It's either going to be a divorce, a legal separation, or a nullity. So you want to mark the correct box, and it's either going to be of a marriage or a domestic partnership. Just to be clear what a nullity is, it's when you are asking the court to find that the marriage was either void or avoidable. And a grounds for a nullity, it can be either a marriage of force, fraud, if one of the spouses suffers from a physical or mental incapacity. It could be if one of the spouses was legally underage at time of marriage, or it could be if one of the spouses was already married or in a domestic partnership at time of marriage, or domestic partnership. So if you fall under one of those categories and you want to ask for a nullity, you can check that box, and there will later be a process by which you can prove that to the court. Below that, in field number 1, you need to correctly identify what is your legal relationship. Either you are married or domestic partners. And if you are domestic partners, you need to mark the box that correctly identifies if your partnership was established in California or not. Below that, you need to mark the box that correctly identifies your residence requirements. If you're filing for a divorce, you need to have been a resident of the state of California at least 6 months prior to filing. And a resident of the county in which you're filing, and at least 3 months prior to filing. So if you meet those residency requirements, you can mark box 2A and identify whether it is the petitioner or respondent that meets those requirements. If it's both of you, you can mark both boxes. If it's a legal separation, you do not need to meet those residence requirements, and you can leave this blank. If it's a domestic partnership, same thing, but there is a box to check that states that your domestic partnership was established in California. You don't necessarily have to be a resident or have a domicile in California to dissolve your partnership here. If you are of the same sex and were married in California, but you currently live in another state that does not recognize your marriage and will not therefore dissolve your marriage, you can file for your dissolution of marriage or legal separation in California, and you would just need to state that you are filing in the county where you were married and list where you are both currently living in. Below that, you list the statistical facts, and that includes date of marriage, date of separation. Separation is going to be an overt act taken in furtherance of separation, something that you could defend on the stand if you needed to. And you would want to tally up the number of years and months from date of marriage to date of separation and include that in line 3A3. If this is a domestic partnership, same thing. You would list the date that your domestic partnership was registered in California and the date of separation, and tally up the years and months that you were domestic partners. The next field has to do with minor children. If you have no minor children, you can mark box 4A. If you have minor children, you need to list their names, birth dates, and ages in box 4B. If you ran out of room on this form, you can always continue on in an attachment. And if there is a child that is not yet born of this marriage, then you would mark box 4B2. If there is a child that was born to the parties but prior to marriage, and there was a voluntary declaration of paternity or parentage signed at that time, and you have a copy of it, you can mark box 4E and then attach a copy of that form to this form. The next page has to deal with legal grounds for the dissolvement of the relationship. So again, you're going to identify whether you're asking for a divorce or legal separation. If either, mark the correct box in 5A, and then the basis or the grounds for that divorce or legal separation. And in California, there's only 2 choices. It's either irreconcilable differences, which is going to be the majority of the cases, or that one of the parties has permanent legal incapacity to make decisions. That is something you would have to prove to the court. The easiest option is to just mark irreconcilable differences. If you're asking for a nullity of marriage, again, we kind of briefly discussed those at the top of this video, but if it's based on incest or bigamy, mark box 5B and mark the correct box. If it's based on the age of the petitioner at time of registration or domestic partnership, a prior existing marriage, or that one party has unsound mind, fraud, force, or physical incapacity. If any of these grounds are present, you would mark box 5C and then mark the box that you are basing your nullity request on. If there are children of this marriage, you do need to fill in line 6. And this is just so you understand the basis for a petition. It kind of gives the court a legal framework or guideline of the relief you're going to be asking for through this case. It's kind of like a complaint in a civil case. So your request cannot exceed what is included in the petition unless there is a written agreement later that you both enter into. So you want to think really carefully about what sort of custody orders you're requesting. You're either going to be requesting that one party have legal custody or that the parties share joint legal custody. Same with physical custody. And if you are requesting one party be awarded physical custody, then you can request that the other party be awarded child visitation or parenting time. There are some forms you can attach with more specific orders. You don't need to at this point. I personally think it's sufficient to just sort of say who you want to have legal custody and physical custody, and you don't need to specifically define it, because then you are limiting yourself to the relief that you've specifically requested. The court automatically includes, whenever there are children, the right to ask for child support, even if you don't specifically do so. So that is field 7. But if there are any additional child support orders you want to make of the court beyond just the guideline statewide formula for child support, you can certainly fill that in line 7D where it says other. Spousal support or domestic partner support. California is a state that recognizes the need for alimony and or spousal support. Those mean the same thing. The terms are used interchangeably. So if you're requesting spousal support be payable to either party, you would mark box 8A and list the party that you want it to be awarded to. If you were asking that the court terminate their ability to award support to either party, then you would mark box 8B and identify the party that you want to have their rights to spousal support terminated. If you are asking that maybe the court not make an order for spousal support today, but reserve on their ability to do so later on down the road, you can mark box 8C. And again, identify which party you want that reservation over the issue of spousal support to be made for. And D, if there's anything else regarding spousal support that you want to specifically request, you can list that in 8D. In 9, this is asking for you to list your separate property. Again, separate property are, and I wrote the definition here, but it's anything acquired prior to marriage, after separation, or by bequest, devise, or descent. Those are all fancy words for inheritance or gift. If there are no separate property assets, then mark 9A. If there are, there's a couple different ways you can go about disclosing that information. Mark 9B, and you can either specifically itemize a list of what those assets are. I always like to just give the general definition, and then I'm not boxed in. And this is kind of where we need to stop and talk about whether or not you believe the other side will be participating in this case. If you believe the other side will be participating in this case, then I think the definition I provided is sufficient. And again, you don't have to use this definition. It's just what I do. If you think they will not be participating in this case and that you might need to default them out of the process, your petition needs to be identical to the judgment you plan on filing at the end of this. So my generic little definition here will not suffice. You need to specifically identify those assets that you want awarded to you. There's also a form property declaration if you want to attach that to this. It just helps fill in some of the blanks. You can list what assets you want awarded to you as your separate property on that form. And then finally, you want to say that this are your separate property assets and they should be confirmed to you. The next page has you identify the community property of the marriage. And again, either there are no such assets, and you'd really only see that in a really short-term marriage because people do tend to acquire stuff the longer they are married, or you would want to identify what those assets are. And just like with the separate property, you can use the property declaration form to do so. You can specifically type it out. Again, if this is a case where you think the other side will be responding and participating in the case, my little generic definition of what is community property is sufficient. If you think that the other side may not participate and you need to make this petition as tight as possible, then you need to list every single community property asset that you think is going to be subject to this, knowing that the court cannot grant or award any assets to either of you via default judgment if those assets are not specifically listed in your petition for dissolution. Finally, if you're requesting attorney fees, then you would want to mark box 11 and who you want the attorney fees to be awarded to. If you are requesting your name to be restored, if you are have changed it for marriage purposes and would like it to be changed back, mark 11B and put the full name of what you would like it to be changed back to, first name, middle name, last name. And then finally under 11C, I always write in here that I want a written statement of decision on all contested issues, just in case this case goes to trial. I want to put the court on notice that I want that. And there's reasons, legal reasons for that. It helps preserve your right to appeal if you have a written statement. So it's just protective language. Finally, you're going to write your name here and sign and date this form, and it is ready to be filed. I hope you found this helpful. Good luck.